Actually, I'm much more comfortable to talk about the situation in Brazil. Of course, we have a very challenge, a good challenge in all Latin America concerning, I guess that all around the world concerning privacy and data protection. But I think that Brazil is a unique country when it comes to say about these issues. First of all, we have legislation that was approved with very hard effort from society, but I think that the main power that helped all of us here in Brazil within this kind of situation is the turbulence, is the storm, I can say that, the political storm, because we had an impeachment process. Data protection is a subject that was really important in the government of the President Luiz Inácio Lula da Silva, and also in the government of the President Dilma Rousseff. And then we had the impeachment process. And since the impeachment process, since the day that President Dilma was not uh, was taken away from the presidency, since that day we have a very we have a pretty much difficulty to go on with the privacy and data protection issues in Brazil, because the president that came after her, Michel Temer, and then our actual president, Jair Bolsonaro, both of them are not so much interested in, how can I say, incomplete all the scenario in Brazil. President Michel Temer was responsible for publishing a provisional measure creating the Data Protection Authority, our ANPD, our Autoridade Nacional de Proteção de Dados. It was created by this provisional measure, but it has never been implemented since then. So we have a legislation today. Part of this legislation is already into force, and this part is precisely the DPA sections, but we don't have a DPA yet. President Michel Temer has never made any kind of effort to implementing the DPA. And since President Jair Bolsonaro was elected and actually became our president, we don't see any kind of step or movement or even in some sort of speech into the direction of implementing our DPA. So we have today a legislation in Brazil that was about to come into force in August of this year. However, we have no DPA to conduct this process. We don't have any kind of guidelines of guidance. We have no guidance of any kind. So companies and also the public sector, public authorities, public organisms in Brazil, we are dealing with a deadline to go through the adequacy in data protection in Brazil, but we have nobody to tell us what to do, where to go, how to do it. So we actually don't have guidance of anyhow. And this is a terrible situation in Brazil, because we can see all of you dealing with data protection for some time. You know that the guidance of the public authority responsible for data protection, the DPA, is the most important guidance of all. And we don't have any sort of of guideline or suggestion, nothing. This is a situation for us with a lot of risk, not only regulatory risk, but also economic risk, because companies in Brazil and also some very small part of public organisms are dealing with adequacy procedures, but with a very good chance to review all these procedures somehow, because it's fully based on European and other countries' guidelines or guidance, which are not necessarily applicable to Brazilian system. So we are dealing with a situation of it's kind of a blackout of guidance, but we were expecting until the time that our legislation would come into force. I mean, until August of this year, we were expecting the implementation of the DPA of our ANPD. But unfortunately, we all have faced coronavirus situation. So the COVID-19 pandemic situation has taken everybody down, and in Brazil particularly, our Congress were really influenced by some sectors that wanted to postpone the entry into force of our legislation. So we had a highly effective pressure, political pressure, under the senators, and a bill suggesting the postponing of our legislation was presented by one of the most important senators in our country, the first vice president of the Senate, Senator Antonio Anastasia. And then we heard that this bill, proposing a lot of solutions in civil law, not only about data protection, but also about data protection. This bill was made with the support of the president of our Supreme Court, Minister Dias Toffoli. Well, this scenario, of course, was really convincing, and then our Senate approved this bill and sent it to the House of Representatives. House of our federal deputies were dealing with this bill until last week. The situation in the legislation, in this bill, was a postponing of both the entry into force of our majority of our legislation, of our LGPD, and a little part of it related to the sanctions were postponed to August of next year. So we had two postponing suggestions. One of them was the big part of the LGPD that would come into force in January 1st of 2021, and the sanctions would be postponed to August 1st of 2021. So we had this scenario. Well, but in Brazil, nothing goes easily as we think. And then, in the time that the bill has been discussed in the House of Representatives, our President Jair Bolsonaro published another provisional measure postponing basically the majority of the legislation to May 3rd of 2021. Well, so today we are facing the following situation. The House of Representatives approved the bill. We have a bill proposing the postponing in two situations of the LGPD, and we have a provisional measure postponing just one situation, just one date. So we have January and August in the bill, and we have May in the provisional measure. So the deputies approved the bill dealing just with the postponing of the sanctions to August and the postponing of the big part of the LGPD was transferred, the discussion was transferred to the provisional measure. What we have now, not so much of a clear future of our legislation. We can say that, in my analysis, the postponing of LGPD is 99% effective, so we can deal with the situation of postponing of the big part of the most part of LGPD, but we don't have a date. We have yet not somehow of a deadline of it. That's not so much of a rational thing to say, but because senators can change the legislation yet. And this bill approved by the House of Representatives, it returns to the Senate, so the Senate can still make some changes, restoring the January, August postponing. But we have also the provisional measure going on in the Congress. Now we have the Congress working. Both houses must approve the provisional measure. And then the rapporteur of the provisional measure, he or she can change the deadline to any date, any time he or she wants. So of course that we are expecting everything to be centralized in the President Bolsonaro proposal. It means maybe in May 3rd of 2021. But I've heard that some sectors of our society want to postpone a little further than May. So we've heard some efforts in the direction of postponing to everything to August 2021. There are some pressure into the suggestion of postponing the legislation to December or even December 2021, or even January of 2022. So privacy and data protection in Brazil is something that is not yet quite clear. We actually don't know what to see, what to expect. We all know that the postponing is almost a fact. However, we don't have an expectation. What's the deadline? What's the final date in which we should all be concerned of making our efforts in the adequacy procedures? So meanwhile, we have a very tough discussion in our society concerning the fight against coronavirus with the processing of personal data. It's all around the world. I know that, I can see. But in Brazil, the lack of legislation about it is making the fight of coronavirus a very difficult strategy. We had a provisional measure published by our president demanding the sharing of personal data between telecommunication companies and our Federal Institute of Research and Statistics. And this provisional measure had no elements of purpose, of proportionality, of adequacy, of technical and cyber security measures that should be taken. So due to all this lack of view lack of vision of our president, some political parties and our Federal Bar Association provoked the Supreme Court, and with some judicial strategy, they the suspended the provisional measure. So we have now, we say here, we have a statistic blackout due to the situation, because we had no official measures protecting, dealing with the protection of our personal data of our citizen. So in Brazil, we have this situation. In one hand, we have a president that does not implement the DPA, our national DPA, and in the other hand, we have the same president that demands the sharing and processing of personal data to fight coronavirus, but with no safeguards, with no protection, effective protection of privacy of citizens. So we have no we have no way to leave this situation. We need our legislation to come into force, even if it should at least, maybe at least, answer some basic questions on data protection and privacy issues. But we have no authority in Brazil that could answer those questions with legal attributes or legal competence to answer all these questions. So basically, in Brazil, the scenario is really uncertain. That's bad for business, bad for society, bad for citizens. We are facing a very high probability of postponing the legislation, over 99% certainty of postponing our legislation. We don't have, we need somehow, we need in Brazil some possibilities, legal possibilities, to fight coronavirus through the processing of personal data, but we have no safeguards, no legal safeguards, because everything necessary to this is entitled in the LGPD. So no LGPD, no data protection safeguards, no data protection issues, and to all our citizens, our companies, public sector, public organisms, that's not a very good. It's not a good news. It's a terrible situation we are facing here, and we hope that Congress at least can manage some guidance about it. But I think that in Brazil, data protection is a subject already put in the judicial system, legislative system as well. Even if we postpone the entry into force of our legislation to this year, to later this year, maybe to next year, data protection is going to be a subject really tested in our judicial courts. It's already being tested in our judicial courts. We have already some judicial procedures discussing data protection concerning some specific companies, mainly companies like telecommunications companies. So, but we have already some popular actions discussing the processing of personal data by some governments, some state government, through some companies that claim to anonymize data or claim to respect privacy. So these, I think we have maybe 4 or 5 popular action, as we say, in Brazil. discussing the situation, and the lack of a federal authority, a national authority specialized in data protection is going to make all this discussion done by judges, not by technical and specialized technicians in our government. And that's very strange and maybe not so much of a good situation, because we know that judges are not specialized. Some judges can be specialized in some issues, but in data protection in Brazil, we have no member of our government or our judicial courts specialized in data protection. So we're going to have decisions, court orders, and other judicial decisions discussing data protection and privacy without the proper technical knowledge. So, well, that's the scenario in Brazil. I think that we are waiting yet to the final word of our senators and our deputies concerning the provisional measure postponing the entry into force to May. The bill I mentioned should be approved by the Congress, but without the suggestion of postponing the legislation. So everything is going to be centralized in the provisional measure. But the provisional measure is yet to be discussed and approved. So we have maybe until August or the beginning of September to do that. And that's also a very dangerous situation because our LGPD comes into force on August 16th, 2020. So there's a possibility of the discussion into being yet in the situation of the parliamentary debate, and possibly the legislation can come into force before the final discussion and approval of our senators and deputies. So we have a window of maybe 15 days in which the provisional measure can be approved after the coming force of our legislation. So our prediction, 99% of chance of approval, is yet a very good chance. However, in politics, at least in Brazil, nothing is sure, nothing is certain. So we expect that all this mess, as I can say, to be solved before the entry into force of our LGPD. So, Mr. Kotz, I'm not sure if I have time or not. So, if you have some questions, I can try to
Sure.
answer.
Sure. Thank you very much for talking about Brazil specifically. Actually, Brazil is something that we haven't seen before regarding data protection all around the world, mainly because the data protection bill was debated during one period when we have one specific president, then we change it. And when we change it, we even changed the way we see data protection in Brazil. I would say that before, all the government was a little bit more worried about data protection. And the two other presidents that we had right after, maybe this is not the biggest concern for this specific two presidents, especially the one that we have nowadays, which is President Bolsonaro. Reason why data protection in Brazil is something that the government is not giving as much as attention as we would like to. This is just my opinion. Probably there's going to be it's going to be postponed. That's something that probably will happen, mainly because of the current COVID-19 events that the whole world is facing nowadays. We just don't know the exactly date when the data protection law will become into force, but this is something quite sure that will happen. So as Fabricio said, probably with all the fines will just be something to be worried. Maybe it will definitely be in the middle of the next year, but we don't know if the law itself will become into effect right now in August, or if it's going to be January, or yeah. The fact is that we don't know.
Yes.
But data protection in Brazil, I would say it's something that is already into our society. I think that we've been talking a lot more about data protection in Brazil. It's something that some companies are becoming a little bit more worried about it. As Fabricio said, we already have some lawsuits which are already debating data protection in Brazil. So, and Brazil represents a big number of internet users. So definitely, if you want to be an international data privacy professional, you should definitely understand what goes on in Brazil. If you want to become an international data protection officer, for example, or a chief privacy officer, we from GetGlobal understand that you should at least understand a little bit about GDPR in Europe, and especially what those national authorities that have to say about the GDPR. You should know something about the CCPA, the California Consumer Privacy Act. Definitely, you should follow all the debates about the India Data Protection Bill, which might be some mix of things. And Brazil, it's the same thing. Brazil has a data protection law, I would say a GDPR-like data protection law. It's almost the same thing that we have in Europe. It follows the same standard. It doesn't follow the American standard, let's put this way. But of course, we have in Brazil the LGPD, which is the General Data Protection Regulation law, has its own Brazilian flavor. It's not the exactly same thing that we are going to find in Europe. So if you want to become an international DPO, definitely you should follow what's going on in Brazil regarding data protection. And just to help a little bit with this debate here, I would like to also talk a little bit about some other countries regarding Latin America. I don't know if you guys can see this map here. Fabricio, can you give me the feedback? Can you see it?
Yeah, it's okay.
Okay, great. So just talking a little bit about Latin America, Brazil has its own law, as Fabricio said. He's one of the most well-known data privacy professionals in Brazil. So no one could say anything more specific about the Brazilian data protection law than Fabricio. Fabricio has helped the Brazilian Congress with the help of some Brazilian data privacy specialists to draft the general data protection bill in Brazil. But we have to remember that there are, of course, some other countries in Latin America that has its own data privacy bills. So here's how other Latin American countries tackle data privacy. Argentina, for instance, since 2000, Argentina's personal data protection law has guided how data is processed and protected. So Argentina has its own data privacy law. For the past year, lawmakers have debated a replacement bill that would more get closer and align with the GDPR. So Argentina has one data protection law. It's not a GDPR-like legislation, but this is something that they are working on nowadays. So among other mandates, it requires that employers obtain consent from individuals before data is collected, for example. Another example is Chile. Chile, the country's personal data protection law covers how personal and private information can appear in databases and requires the consent of individuals before it's collected. In 2018, Chile joined other Latin American countries, including Colombia, Ecuador, and Mexico, when they amended their data privacy law and even amended the country's constitution to make personal data a constitutional right. So the update of what they call Article 19, number 4, says that any person who suffers harm as a result of an arbitrary, of an illegal act or omission can seek relief through a constitutional protection act. On the other hand, Colombia has also a data protection law, regulates personal data processing and databases, and requires that an employer provide a privacy notice and obtain express consent before seeking any personal information. So we need to take close attention that Colombia has its own law. Same thing regarding Mexico, for example. So several laws and regulations spell out abroad requirements from companies that seek personal information, including how it may be collected, used, communicated, and stored. Since 2010, Mexico has enacted laws furthering the country's restriction positions on data privacy, including the federal law of personal data protection processed by private persons. That's the name of their data privacy law. So nowadays, Mexico, let's say that follows a little bit more of a US-like way of regulating data privacy, mainly because they don't have one national and comprehensively data privacy law, but some sectors are regulated when we talk about, or when it refers to, the processing of personal data. The last country that I just want to bring attention is Guatemala. Unlike any of its Latin American neighbors, the country has no data privacy law. There also are no specific restrictions on how employers screen their workforce. However, the country's constitution does provide a guarantee to free employment and also prohibits discrimination based on individuals' criminal past. So as we can see, some of the countries that have their own data privacy laws, some of them are just about to debate a new drafting of their law, and some others have some restriction more related to the relationship between employees and employers. So that's how most of the Latin countries nowadays pretty much regulate the use of personal data in Latin America.